Healthy baby skin starts from the bottom. Pampers Swaddler's diapers absorb wetness away from the skin better than the leading value brand, with up to 100% leak-proof protection to help keep your baby's skin dry.
Good morning, good morning, good morning, everyone. Good morning. Welcome to the session 2 of the George W. Crockett Community Law School. My name is Chewy Correga. I have the pleasure of serving as General Counsel for the Detroit branch of the NAACP, which is your sponsor putting on this law school for you. This is an interactive school. It is designed to combat, grasp, and hold on to, and end up making mistakes. So let me tell you first a little bit about the George W. Crockett Law School. It is part of what we call the Thurgood Marshall Legal Initiative. And I hope all of you know that name, Thurgood Marshall, and I hope all of you know that name, Ruth Bader Ginsburg. Because Justice Marshall was the first African-American justice for the Supreme Court of the United States. And he had a saying that I always like to repeat. He said, remember his words, you do what you think is right and let the law catch up. So we honor Justice Marshall by naming our legal initiative after him and also after Ruth Bader Ginsburg, who was a very dedicated and strong advocate for civil rights before she took the bench on the U.S. Supreme Court and at all times when she was a member of that distinguished court. This morning we have, by the way, George W. Crockett, I'm sure all of you know, was one of the most in the area. We named the law school after him because of his aggressive form of legal representation. Kinds of folks, and primarily those that were under attack and underprivileged. You've got some written literature available to you. The presentation is over. We'd be glad to meet with you and talk about these legal giants in our community. But right now we're going to bring forward for you government, First Amendment, freedom of expression, etc., in order that folks can your rights in these circumstances. So we're going to have several good speakers for you today, and there will always be an opportunity for question and answers afterwards, and then when the address committee. As you can imagine, that would cover everything from attending to folks being court watch, where we watch courts and make sure that they're not abusing citizens, things of that nature. I'm going to ask my good friend and colleague
and in person here. Just want to plug, absolutely, thanks Chewy, appreciate all of his work as the general counsel, the head lawyer for our branch. Very very critical election, and we hope not too tumultuous, but we do expect some shenanigans. That's all I'll say about it. Very dynamic person who is an attorney with the ACLU. One of the things I loved about our workers like myself, or those whose civil rights are trampled on, like Attorney Davidson, it is a mission, because you realize spent 7 years at the Sharp firm representing workers in employment discrimination cases, and she's joined the ACLU in 20 of the boards and has a number of other activities in the community. So I want to thank you, Ms. Davis. Why don't you come up and she's going to talk to you.
So I always hear that in my voice when I have something pressing. I mean, I hear it in my head, in his voice. So thank you so much for having me today. And I'd really love to show some love for the Detroit branch of the NAACP. This is no small undertaking. If you're in the room, you see all these cameras and tech, and they worked really hard on putting this together, and it's more than just today, it's several sessions, so really hats off to them. It's several sessions, so really hats off to them. Richard just went through most of my bio, so we don't need to a minute ago. The rights of have to look to history to see that protests can bring awareness to injustice and economic and social abuses. Sometimes you can show power in numbers, and sometimes we can make the people in power a little bit uncomfortable enough that they want to make that change too. So we can motivate people through people power and our right to protest. And I've got in front of you just a little quick primer on protest rights. If you're out there and you need something in your back pocket to kind of talk about, to refer to something, you think something is not quite, just carry that with you so that you have an awareness about your rights. I've also left a card for everybody at your respective seats, so all questions about anything I say today or anything that might come up for you in the future, which I embrace wholeheartedly. But I do think there is one thing that is really, really important that we don't talk about enough, don't often address here in these presentations. I and other speakers who have agreed to come speak with you are going to give you a lot of information about your situation alive, okay? So generally, I say that when I do these Know Your Rights presentations as it pertains to police stops. Protest, depending on what you're protesting, you can be subject to abuse and hostility from people who don't want you speaking out. Are more likely to face discrimination in addition to the risk of hostility that's always present. So yeah, it's always crucial to know your rights, but if you're in, and so let's take a deep breath and move forward. Okay, I know you want to hear about protesting specifically, but as they pertain to our right to protest, these are kind of the big ones, right? So our right to protest comes from a combination of these rights, which, among other things, as I've said, protects against government restrictions on the freedom of speech, the right to peaceably assemble, and the right to petition the government for redress. The right that is most commonly associated with our right to protest is obviously this right to peaceably assemble. And that is the right of people to come together. A right to peaceably assemble will cover things like meetings, sit-ins, strikes, rallies, and of course protests. Manifest together in the form of a protest. However, when we talk about the First Amendment and the case law surrounding the right to protest, we all know that the First Amendment to the United States Constitution protects nearly all speech. And speech can mean a lot of things. It can be how you usually think of it, what I'm doing right now, right speech. But it can also mean yard signs, flyers, you're wearing a slogan on your clothing, right? This is all speech. It can also be something symbolic that you're doing to express yourself, like wearing a black armband or even burning a flag. So a lot of things are considered speech. And in turn, many of things are considered to be protest activities, right? So we know, for example, that the case that involved the black armband, which is Tinker versus Des Moines, which is decided in 1969. This is a case where the Supreme Court ruled that a school district could not prohibit students from wearing black armbands to protest the Vietnam War. And another example of expressive conduct as a form of protest happened in Texas versus Johnson in 1989. This is where a person was prosecuted for burning a flag in front of City Hall as a way of protesting Reagan's policies. And the Supreme Court said, that's speech, you can't criminalize it. So just to give you kind of a picture, speech, protest, it doesn't always mean a giant group of people gathered outside of a place with signs and bullhorns, but it can, right? It can mean a number of things. Now, most speech, even that which is offensive, is protected. This means the government can't punish you for it. And that is an important thing that people often forget. And we will talk about why I make that distinction at the end here, about how the government can't punish you for your speech. There are the first is fighting words, and this only applies to speech that is directed at a specific person and is likely to provoke a violent reaction based on the totality of the circumstances. Now, when we say the totality of the circumstances, that means we're not looking at one specific thing. We're not just looking at the speech. We're looking at everything surrounding the statement or the speech that was made to determine whether it's fighting words, whether it's designed to provoke a violent reaction. So what this usually means is that the words themselves are not likely to be enough to constitute this kind of fighting words non-protection doctrine. Always going to be fact-specific based on every factor that can be analyzed. So, for example, in 1971, it was decided that a jacket that says F the draft is not fighting words, not directed at one person, and not designed to provoke a violent reaction. And in 1974, we had a case where there was a law against obscene language directed at the police in New Orleans, and we found that the obscene language was not fighting words. That's not going to be enough. So just kind of some examples there to show you it is actually very difficult to kind of fight and fall into this unprotected speech exception for fighting words. The prohibition against obscene language toward the police was found to be too broad. When we're looking at whether something is words, the things that a court is going to look at is going to be whether the speech is coupled with aggressive conduct, the volume of the speech, induce or otherwise persuade another person to engage in a crime of violence against a person or property. And that's something, again, evidence is required of likely and imminent violence. You are encouraging a crowd to get violent, and you're encouraging them to do it now. And I'm just going to leave that there and move on to the next one. Another exception is true threats. This one looks a lot like fighting words. True threats cause a person to feel threatened, okay? For example, in Virginia, in 2003, there was a law that banned cross burning with the intent to intimidate. And the court found that this does not violate the First Amendment. So the law itself was allowed to stand because burning a cross with the intent to intimidate is not protected speech. It is a true threat. And so Virginia was allowed to criminalize that behavior. Obscenity, we all know this one, right? The case that says we know it when we see it. So obscenity is not protected speech. High bar for obscenity, though. Very hard to prove that something is obscene and therefore not entitled to protection under the First Amendment. And then we have speech related to criminal activity is not going to be protected under the First Amendment. So protesting generally. Let's assume everything else is protected. What does that actually mean? It means, again, the government can't unreasonably restrict the speech. It means the government can't retaliate against you for making the speech. So let's talk about what restrictions the government can enact on the right to protest. And this is largely going to depend on where the speech is occurring. So we do this kind of forum analysis to determine where the speech is happening, to determine how much protection it gets from government restriction. So the first one, and where your rights are the most protected, is the public forum, the traditional public forum. Your speech enjoys the most protection here, and there are two kind of types. There's a traditional public forum, and then there's a designated public forum, which we'll talk about in the next slide. But a traditional public forum is a place which, by long tradition or by government fiat, have been devoted to assembly and debate. So, these have been traditionally open to the public for expressive activity, and used for communicating thoughts between citizens, discussing public questions. So, for examples, these are your public streets, sidewalks, parks. When we think of those places, these are places that people can go freely and exchange ideas, right? So in a pub broadly, right? But they can only be regulated and I'm gonna back it up a little bit so that it makes more sense. So let's drill down on all of these things. Case law says that a content neutral provision is justified without reference to the content of the regulated speech. That gets us absolutely nowhere, doesn't it? We don't know what that means from looking at it. What's content? I think this concept is actually much easier for folks to grasp if we talk about it from the opposite point of view. What is a content-based restriction, right? Content-based is the opposite of content neutral. So a content-based regulation would be, for example, something that bans all political speech or all religious speech, or even all speech that ridicules a person or group. These are content-based restrictions, so they are not content neutral. It does not matter whether the government maintains neutrality within the content. What I mean by that is the government doesn't have to favor, for example, Christian-based speech over Muslim-based speech in order to find that a restriction on all religious speech is content-based. Content, it's the category, it's not the specifics within the category. If the restriction is a content, prior slide, to a test that we call strict scrutiny. And what that means is that the burden is on the government to, and this is actually the hardest test in constitutional law for the government to pass. Very specific examples of how the restriction protects public health or safety. It can't be a general, statement crime, national security, and of course ensuring that the government is compliant with its constitutional obligations. Aesthetic reasons, narrowly tailored. This means that the government needs to show that its regulation is using the least restrictive means to reach that objective that has survived strict scrutiny or this test, would be these 100-foot buffer zones at polling places. And it and the government has generally been able to show that its compelling interest there is to protect voters from corruption, and until we know that 100 feet is the least restrictive way to meet that objective. In the speech context, not many content-based restrictions beyond that allowed to impose reasonable time, place, and manner restrictions on speech. What that means is that they're not censoring the speech itself. They're just moving the method or the location of the speech. So for example, you're not gonna ban all music in the neighborhood, but you might say that you can't play it loudly at 2 o'clock in the morning from your front porch, right? That would be a valid time, place, and manner restriction. And we don't get at the content of the music itself, right? It's just moving it, it's moving. I had a law professor that used to say, we're just moving this speech around. That's exactly what this is. Also, for example, a law that prohibits blocking traffic when you're protesting is probably gonna be a valid restriction, right? It's health and safety, it's public safety. Valid time restrictions, if we're talking about time, place, and manner. I know I've moved on to this next slide a little bit prematurely, I apologize. Valid time restrictions are going to include, just like we talked about just a minute ago, banning amplified sound in residential areas during a certain time of day, limiting activities in busy traffic areas at rush hour. A place restriction might include specific areas for public, prohibiting blocking access to public buildings during a protest. So the government is allowed to impose those types of restrictions. So this is when the government has intentionally opened property for expressive activity by the public, even if that property is not traditionally a public forum, like the one we talked about in the last slide, right? So this is government property that wouldn't ordinarily be a public forum, but the government has opened it up to make it so. The government is not required ever to create a designated public forum, nor are they required to maintain it after they do so. But if they do, their ability to limit speech is subject to the same restrictions as it is in a traditional public forum. So your examples are going to be leased municipal auditoriums, university meeting rooms that student groups can use. There's one case where a university yearbook was found to be a designated public forum, because a university is the government. It's government run, unless it's a private university, right? Schools and universities. There's another case where the court found that advertisements on the side of a bus can be a limited public forum. So when that happens, the government is subject to the same restrictions as in a traditional about the government has the most control over speech occurring here. By exclusion, we know that this is an area that's neither traditionally used for expressive activities, the way that our traditional public forums are, nor are they set up or opened up for expressive activities the way that our limited public forums are, okay? So examples of a non-public forum, so again, these are gonna be government buildings, jails, hospitals, and military bases. These are not places where you typically think you're gonna go there and engage in some expressive protest activity, right? So the government can control access to these places based on subject matter and speaker identity, so long as the distinctions drawn are reasonable in light of the purpose served by the forum and are viewpoint neutral. I have again thrown a lot of legalese at you, and so again, we will break this down to be a little more digestible. We've already talked about content neutral. What's viewpoint neutral? What is that? So let's go back to our content examples. A law banning all political activity would be content-based, right? Reasonable in light of the purpose served by the forum, right? And I'll give you an example in just a moment. But all political speech. It can't just ban, for example, political speech made by Democrats, okay? So that's drill example. We know even in a non-public forum, what that tells you is the government can't ban your speech just because it doesn't like the message. Supreme Court said that even under this very relaxed test, an airport could not enact a ban on all First Amendment, and the court said, yeah, this is a non-public forum, but no, this ban is not reasonable in light of the forum, and the non-public forum. Speeches and handbill distribution. And Dr. Spock challenged the restrictions, saying that it should be a public forum because the Army, a restriction was reasonable to further that purpose. So that's an example, one example of a government not passing that test, and one example you all. But just for awareness, I'm gonna touch on it with you. I tend to see permitting issues most often when it comes to like permit for a free speech activity. But if you wanna have, for example, something that blocks traffic, something like a parade where you're at site usually, And I just have to point out here that just because there's a permitting process and it's on the city's website, that doesn't always mean place and manner restrictions. Meaning, for example, a city can say, you can't shut down this street, but we can let you have your parade on this street. They can probably say, for example, you can't shut down Woodward. We're not going to block off Woodward for you. But what they're not going to be able to say is, but let me put you in this tiny residential necessary for traffic control or public safety. So there are two kind of main things that a municipality can't do when it comes to the permitting process. For one, they can't give themselves sort of unfettered discretion to approve or deny permits. Like if you look at a permitting process and all it says is, you know, submit your permit and the city will approve or deny it in their own discretion, but it doesn't have any parameters, it doesn't have a rubric for how they're going to evaluate. That is likely going to be unconstitutional because it opens the permitting process up for arbitrary or abusive decisions, right? It gives them too much control over the speech. They need to have clear, articulated parameters for when they're approving or denying permits. The other thing they can't do is deny permits because they don't like your message. They can't do that kind of content-based, no, you don't get this about applying where and you don't exam banned, or is it all pride speech is banned? And you know, the government not being based on the content of the message also applies to the government not being able to deny a permit because they are afraid of attending this festival. And most of the people just told attending this festival. And most of the people just told them that they were unwelcome or, you know, told them to leave. But some people also a pretty good example of how the First Amendment also protects speech. Also a pretty good example of how the First Amendment also protects speech that is offensive. Talk to you about just a handful of causes of action that may Richard may be checking in on this in the employment context when he comes up here. But, you know, very broadly speaking, the government may not take adverse action against you for exercising your First Amendment rights. And so let me just give you some examples of what that might look like. Maybe you spoke out against the mayor or city council, and then on their next agenda, they take away a business license for something that you own. Maybe you speak out against the mayor and decide to run against him, and then you're denied a permit to have your own event in a local park. There is also such a thing as retaliatory harassment, and that's where it's a series of events that occur, right? Like maybe you speak out against the police department, and then the next thing you know, like the police are always on your street and they're watching your house and they're ticketing you for dumb things, that kind of thing. The main thing to consider is whether the thing that is happening to you would tend to deter someone from speaking out. Is that something that would ordinarily chill someone's speech, would make them be quiet and not speak out any further? Another cause of action that we've heard of before is excessive force. And obviously what this means is that the government may not use more force than necessary in any given situation. These claims are almost always pretty fact specific because there are going to be some situations where some level of force is necessary. So that's why they're so specific. So this is really one that if you feel like it happened to you, you're going to want to try to remember all the details that you guys, like a straight up beating, right? Sometimes it is, sometimes it's they're unnecessarily tasing you, they're unnecessarily being ticketed or driving. Additionally, if police officers have a reasonable suspicion to believe that you violated the law and there's a local law requiring that you show ID when the police have reasonable suspicion, then you've got to identify yourself. I know those kind of local laws exist in Ann Arbor and East Lansing, not sure about the rest of the state. In general, if you're asked for an ID and you have it, it's not worth it to refuse. It's not worth it to refuse unless you happen to be undocumented, right? Because in which case, you should know that showing an ID could result in an ICE detention. But generally it's not going to be worth subjecting yourself to further abuses from the police to assert that you don't have the right to produce ID if you have it, or the right to not produce ID if you have it. And police can't search your bags unless they have probable cause to believe that you have a weapon or contraband, or evidence of illegal activity. In some situations, if there's a very large protest and police have marked out like a secure area, they can search your bags in that kind of secure area, but they also have to give you the opportunity to refuse the search and leave the secure area. Like, they have to give you that choice. Same thing if they want to search you personally, right? Like, not a bag, but like only if there's reasonable suspicion that you were engaged in, or if you are detained during a protest, stay calm,